Hey, it's Cam here. Welcome back to Cam's Corner. Grab a cuppa, settle in, because today we're diving into one of those topics that sounds like it belongs in a law textbook, but actually shows up in real-life investigations all the time. Legal Professional Privilege, or LPP. If you've ever wondered what you should put in writing after an incident, who's going to see it, and whether it can come back to bite you in court or with the regulator, this one's for you. So, plain language first. Legal professional privilege is basically a protection that lets a client keep certain communications with their lawyer confidential. Not just secret for fun, but secret so they can get proper, honest legal advice without worrying it'll all end up in court or with a regulator later. If LPP applies, you can usually resist handing that material over in legal proceedings and to regulators, subject to the rules in your jurisdiction. Now, in an incident context, why does that matter? Imagine there's been a serious injury at work. You investigate, you realize there were big gaps: training, maintenance, supervision, all of it. Those findings are exactly the sort of thing a regulator or a plaintiff lawyer would love to wave around in a hearing. LPP is about which parts of that investigation can be ring-fenced as, "This was done for our lawyers so they could advise us," versus, "This is just routine safety paperwork that's fair game." That brings us to a key distinction people muddle up all the time: legal advice versus business as usual safety docs. Legal advice privilege usually covers confidential communications between you and your lawyers and documents created for them, where the point is to get legal advice or help them run or defend litigation. So if your lawyer asks for a factual investigation report so they can advise you on legal risk, that report might be in the LPP zone. But the same event might also trigger all your normal WHS processes: recording the incident in your system, updating your risk register, notifying the regulator, doing toolbox talks, that sort of thing. Those are ordinary safety or compliance documents. They exist because the business has to manage risk and meet its duties, not because a lawyer needs them. Slapping privileged and confidential on the top doesn't magically turn them into legal advice. The law often uses what's called the dominant purpose test to sort this out. I always picture it like asking, what's the main game here? If a document was created for more than one reason, you look for the dominant, the ruling purpose. Was it mostly for getting legal advice or running litigation? Or was it mostly for operational, safety, PR, HR, or some other business reason? So with an incident investigation, if the real driver is, our lawyers need a detailed analysis so they can advise us on our legal exposure, potential prosecutions, and strategy, then there's an argument the dominant purpose is legal, and LPP might apply. But if the main driver is, we always do an internal safety investigation to update our procedures, tick off our policy, and show the board we're on top of things, then the dominant purpose is more safety/compliance than legal, and privilege is much less likely to stick. And look, the dominant purpose test is a bit of a line ball sometimes. Humans are messy. There's rarely just one purpose. But for privilege, legal has to be the top dog, not just one of a long list of reasons. If legal is an afterthought, like calling the lawyers once everything's already written, that's when, to use a local expression, your privilege argument is on pretty thin ice. Now let's zoom into WHS incidents specifically. The world of inspectors turning up in high vis, improvement notices, and those dreaded letters asking for documents. How does LPP actually operate in that environment? In a serious WHS incident, you've usually got three tracks running at once. First, you've got your legal track. Are we going to be prosecuted, sued? What are our obligations right now? Second, you've got the safety learning track. What went wrong, and how do we stop a repeat? And third, you've got the regulator and sometimes the union or other stakeholders wanting information and documents. LPP really only lives on that first track, the legal one. But what you do in the other two can affect whether the protection holds. One big misconception is that LPP is automatic for anything that looks legalish or happens after lawyers are mentioned. It's not. Just because an incident is serious and there's talk of court doesn't mean every email and every PDF after that moment is magically privileged. the dominant purpose test still applies to each document and each communication. Another trap, relying on labels. People write subject to LPP or prepared for legal advice in the header and think they're sweet. Those labels can help show what you were intending at the time. But if what's actually going on is a normal internal safety investigation, a regulator or court can look straight through the label and say, "Nice try, but no." There's also confusion about who owns the privilege. Generally, LPP belongs to the client, the organization, not the individual safety manager, not the external investigator, not even the lawyer. The lawyer helps protect it, but the organization decides whether to assert it or waive it. That matters when, say, a regulator issues a notice, like an S155-style information request, and different people around the business start handing stuff over without checking who can actually decide to waive privilege. Let's make it concrete with a few examples. First, something that's more likely to be privileged. Your external lawyers are engaged after a serious fall from height. They formally instruct an investigation consultant to interview witnesses and prepare a report strictly for the lawyers so they can advise on prosecution risk. The terms of engagement, the instructions, the draft and final report, and the communications between the consultant and the lawyers may all be candidates for LPP, assuming the dominant purpose stays legal and things are kept confidential inside a need-to-know group. Compare that with a standard internal incident report done in your usual software, because your WHS procedure says log all notifiable incidents within 24 hours. It goes to the safety team, the ops manager, maybe the supervisor. That's routine. Even if someone CCs the in-house lawyer, the primary purpose is safety system compliance, not legal advice. That sort of doc is much less likely to be covered by LPP. Or take toolbox talk notes after an incident. You've pulled the crew together, gone through what happened, reminded everyone about harness checks, and scribbled a few bullet points on the sign-in sheet. That's classic safety communication. Very useful, but not legal advice material. On the borderline, you might have an internal lessons learned deck that's originally prepared for the lawyers to review and advise on, and then later someone wants to reuse it for a board risk workshop or training session. That's where privilege can start to slip, because you're drifting away from that dominant legal purpose and sharing it more widely. We'll unpack those pitfalls in the next bit, but the key idea here is, in WHS land, privilege is there to protect the legal advice and litigation piece. It doesn't blank out your whole safety system. Alright, so if you actually want to run an investigation under privilege, how do you set it up properly without turning your safety system into a legal black box? Because regulators do not love that. And frankly, it's not great for learning either. Step 1 is getting legal involved early and clearly. That usually means the organization, through in-house or external lawyers, formally deciding we need an investigation, primarily so our lawyers can advise. The lawyer then instructs whoever is doing the investigation, that might be an internal manager, might be an external specialist, and that instruction is documented. What's being asked for, that it's for legal advice, that it's confidential. From there, you keep the communication chain tight. Privileged communications go between the lawyer, the client reps who genuinely need to know, and anyone engaged to help the lawyer give that advice. You don't email the report around the whole distribution list for awareness. You don't drop it in a shared drive labeled incident stuff, everyone welcome. That's where things go pear-shaped. Because one of the big risks is waiver of privilege. In simple terms, waiver happens when the client behaves inconsistently with keeping the communication confidential, sharing extracts widely, relying on the content to persuade others, or selectively disclosing the good bits. For example, if you tell a regulator, our privileged investigation shows we've got a very strong safety culture, and you lean on that as part of your argument, they may say, well, if you're relying on it, we want to see it. Another risk is mixing privileged and non-privileged content into one mega document. If your legal advice report also doubles as the official safety investigation, the training tool, and the board pack, you're asking for a fight about whether the dominant purpose was really legal. A cleaner approach is often to have a privileged investigation stream feeding the lawyers, and then a separate, more operational safety summary or corrective actions plan that you're happy to share. On regulatory notices, like an S155 style demand for information, most frameworks recognize that LPP is a legitimate ground to withhold documents, but you've got to handle it carefully and with legal advice. That might mean identifying which documents you claim privilege over, providing a description or schedule, and still answering factual questions by other means. You're not stonewalling, you're just not handing over the lawyer's homework. For safety leaders and managers, the practical challenge is balancing learning with protection. A few pragmatic tips. 1. Don't assume everything needs to be underprivilege. Save it for the higher risk, legally sensitive incidents. Your day-to-day near-miss reviews can stay as open learning exercises. 2. Be clear in your documentation. If something is being done under legal instruction, say so and keep it in that channel. If it's a normal safety investigation, don't try to badge it as privileged after the fact. That's like trying to register your dog as a racehorse after the Melbourne Cup. Everyone can see what it really is. 3. Think in terms of streams. Have a legal stream focused on counsel, strategy, and potential liability, and a learning stream focused on controls, behaviors, and systems. They'll talk to each other, sure, but they don't have to be the same set of documents. And 4. Train your managers on who can decide to assert or waive privilege, and how to respond if an inspector asks for something that might be privileged. A simple line like, "I need to check with our legal team before I provide that document," can buy time and avoid an accidental waiver in the middle of a site walkthrough. We'll leave it there for today. LPP and WHS investigations is one of those topics where a bit of structure and early planning goes a long way. You can absolutely learn from incidents and still protect the organization's legal position. You just need to be deliberate about which hat you're wearing when you create and share documents. In another episode, we'll dig into some more real-world twists and what happens when regulators push back on privilege claims. Catch you then.